Does a Social Security judge have to consider your need for the use of an emotional support dog? The answer is yes. The judge has to decide at step 4 whether or not you can go back to your past work, and at step 5 whether you can do other work in the mythical, hypothetical, not real world national economy. One of the witnesses at this Social Security hearing, in addition to you, is going to be a vocational rehabilitation counselor who's never met you. They will have looked at your work history form, they will have heard your testimony, and then the judge is going to give them a hypothetical question about your ability to do work based on your physical and mental restrictions and limitations. Now, obviously, the judge is going to formulate that hypothetical based on the medical records in your file, the opinions of the Social Security consulting physicians, the opinions of your doctors, the opinions of your doctors as expressed in a residual functional capacity form. Now, I find that judges will often make mistakes in formulating that hypothetical, which will result in the VE saying you can do your past work or other work in the mythical, hypothetical, not real world national economy. And so one of the questions that I get from my clients who have emotional support dogs is, must the judge consider my need for that dog in formulating the hypothetical to the vocational evaluator? In the recent case of Lee Lowry versus Acting Commissioner of the Social Security Administration, the 11th Circuit, which covers the states of Florida, Alabama, and Georgia, addressed that very question, and the court held that the judge has to consider all factors affecting a Social Security disability applicant's ability to work from both a physical, cognitive, and a psychological standpoint. And in this case, the court found that the judge's decision was legally wrong and not supported by substantial evidence. Why? Because the judge did not consider Lowry's need for the emotional support dog in the workplace. Now, one of the things that wasn't clear in this decision as to whether the support dog was medically necessary, and the judge did not address that. And as a result, the 11th Circuit remanded the case back to the judge for further consideration. I hope that Larry's attorney will get a letter from the treating provider confirming that this emotional support dog was medically necessary. Judges will often ignore the use of a cane or other assistive devices if not prescribed by a treating provider, and I suspect that a Social Security judge would do the same thing with an emotional support dog unless there's medical evidence that the support dog is basically medically necessary and appropriate. So great win, and I wish Mr. Lowry the best in getting their Social Security disability benefits. If you have any questions about your rights to Social Security benefits, call us today at 727-894-3188. We'll explain the Social Security disability 5-step sequential evaluation, the claims process, how Social Security lawyers get paid, and how we can help you get the Social Security disability benefits you deserve.